the Plessy and Ferguson Foundation. That's Plessy and Ferguson, not Plessy v. Ferguson, which is important because it shows progress being made in our own state. There's lots of stuff that need to be done, but maybe they have some answers and ideas on how to go forward.
The Diversity Committee decided as a whole that it would be a good idea to bring Keith Plessy and Phoebe Ferguson to Centenary simply because of all the issues that are going on in our country. In the past, it's always been Plessy versus Ferguson. But for what Centenary is trying to do and what the Diversity Committee is trying to do, the notion of having a foundation come to college that is Plessy and Ferguson, where you get both sides of these questions trying to address the same issue, was very relevant and spoke to the needs of our students today and of our society at large.
Turn our program over immediately to Keith and Phoebe. Let's give them a hand.
The separate car law that was written in 1890 by Louisiana legislature mandated that we have separate accommodations for black and white passengers on railroad cars. And Homer Plessy's appearance was of a white man. He did not appear to be a man of color. Well, when Homer Plessy sat on the train, he probably could have rode all the way to Covington because he wasn't recognized as a person of color. And he said, "Are you a colored man?" And Homer Plessy said, "Yes, I am, and I'm going to ride to Covington." And he said, "Well, you have to go to the car that's designated for your race. You can't ride on this car." So he refused to get up. So he called Detective C.C. Kane, who was also hired to not only arrest Homer Plessy, but to protect him and get him over to criminal district court, the parish prison area, so he could be booked. And the case was then etched in history. The beginning started on June 7th, 1892.
Today we would expect a case like Plessy to be headline news and to be dominating news coverage for weeks. I think in its time there was such ambivalence and a growing sort of disregard for civil rights, North and South. The Republicans had tried to enforce civil rights and worked for about 4 years during Reconstruction to protect freed slaves. That fatigue set in by 1876, and Reconstruction ended abruptly in 1876. And between 1876 and 1896, I think one could describe it as a period of apathy and lethargy in the North, just kind of wanting the South to get back to governing themselves and not being a Northern concern. Both parties, Republicans and Democrats, were discussing almost exclusively economic policies by 1890, 1895, 1900. So, you know, chances are a story like Plessy versus Ferguson, whereas today we would expect it to be a banner headline, probably was just a whisper.
Ferguson was not from Louisiana. He actually grew up on Martha's Vineyard. He was from a sailing family, whalers, master shipmen. He was born in 1838, and in his early 20s he went to Boston to study law. You know, he just kept with his studies. He finished it and he practiced a couple of years in Boston, and then the war ended, and as soldiers returned to Boston and were, you know, talking about the spoils of war, and, you know, New Orleans wasn't a city that was ravaged by war like Atlanta, that there were opportunities there, and he was literally, you know, a carpetbagger who came down to set up shop in New Orleans in 1865, and that's what he did. His main focus was on, he was sort of anti-gambling and anti-prostitution, and that was really his concern and where he wanted to practice. And he eventually got involved with some of the political figures of the time, you know, worked with them on campaigns and things. And 1890, after both Daniel Day Doon and Homer Plessy were arrested, he was appointed to an empty seat on the criminal district court bench. And that is why he heard Homer Plessy's case. I guess it appeared on his docket randomly, or there was a more political decision that it would appear on his docket. To all the arguments, he seemed to be weighing the law versus the arguments of conductor decide the race of a human being and determine it, and therefore decide whether or not you could ride in the first-class car or not. I mean, how does the law apply to giving someone that kind of power? So that was part of the argument as well. But he eventually upholds the decision based on the, how they wrote the law.
Sometimes the reactions of students was very surprising. I know one young woman started to cry in the convocation because something that she heard struck her so deeply. She was so happy to hear it.
Carefully crafted plan that they had constructed to have him hauled off to jail with not only an arrest taking place, which they wanted, but he was protected on his way to jail by the arresting officer, C.C. Kane, so that he could be brought in, booked, make the case, put the case on the books, and then allow him to be released the next day, because they put up bail for him immediately.
A descendant of Plessy, a descendant of Ferguson, who have such a rich knowledge of the subject matter, brings a couple of things to Centenary College. First, it brings a depth of understanding that I can only pretend to have. I learned this case law through the law itself, the books, some historical accounts. I can't pretend to have the sort of rich oral history that those who have been in these families know.
It was very, very hopeful. The presentation, my reaction to that would be very moved, because you do have these descendants who were on opposing sides at the time, and now they have come and changed it. So it's no longer Plessy v. Ferguson. They've changed the idea behind it to Plessy and Ferguson. So it's kind of, to me, it was just the idea that we can move on and come together and move past things. So it was very, very moving, and it was very enlightening, and it was hopeful, because in today's society we do have a lot of problems and issues, especially pertaining to race. So it was nice to see that these two people come together and are kind of showing us that we can move past these ideas and come together as one, which is the hope that we have.
And in particular, the committee that was formed to fight the segregation law, they were arguing three separate but related legal points to try to overturn segregation. The first was a 13th Amendment argument. They said that segregating the races by law carries on the vestiges of slavery. It's a caste system. It's a badge of slavery was their terminology. The second was a simple equal protection argument. This is discrimination. This is separating the races. It is a clear violation of the Equal Protection Clause. The third, and perhaps the most creative, was a due process argument under the 14th Amendment, where Homer Plessy argued, you are taking from me the property and reputation of being white, which I enjoy from looking white. He said under the 14th Amendment, you can't deny my life, liberty, or property without due process of law. That property is my reputation. And in his briefs to the Supreme Court, he said, in our country at this time, one would rather be a white man, certainly in this society, rather than black. And so he says, you're taking that from me. The Supreme Court quickly brushed aside the 13th Amendment argument, saying that ended slavery, the ownership of people. The whole vestiges badge argument has really nothing to do with the ownership of a person that's different. On the 14th Amendment argument, which today we would perceive as the strongest, I mean, this was a separation of the races and one race saying they're superior. They've shifted the blame to Homer Plessy, saying that this isn't discrimination, this is separate but equal. And so if your feelings are hurt, just understand that this isn't to your hardship. Just buck up and feel some pride. Because if you were in the majority and did this to the white race, they wouldn't be upset and feel inferior and litigate. Neither of you want to be together. That was the justification. No, that's a horrid, illogical part of it, which is what makes this a terrible legal decision. On the last issue of the reputation of being white and having his property taken, they made a cold and ugly argument that you're not white. Your great-grandmother was a freed slave, African American. So you have no claim to that property. If a white person came and said, you've taken my reputation of being white, well, we might listen. but they brushed that aside as well.
Phoebe and Keith both said that they had never been on a college campus where the questions and the answers were so powerful and so penetrating.
To the students for last night's event. It was very enlightening, and we compliment you on sharing your feelings and your thoughts, and it was very informative for us. And it gives us a sense of direction in terms of knowing that everybody's opened this conversation up, we're breaking ground, and we're finding ways to come together.
We should really try to learn our past more so that we can possibly move forward and know about it and not repeat the same things over again, and just that we are all equal. We don't have to be separate. We're all together.